Hi, Attorney Steve Vondran, the litigation lawyer. We are talking in this video the difference between a default and a default judgment under the federal rules of civil procedure. So without further ado, let's head to the Attorney Steve litigation whiteboard. All right, back it up, people. Let's get this backed up here. There we go. Let's get our boxing gloves in there. Fighting for your rights, fighting for your damages. Okay, so we're going to talk a little bit about a default versus default judgment. This is a topic that confuses a lot of people. We'll get some calls from people that say, I just got a default, or I got a default judgment. What do I do? I didn't have a chance. I was never served the papers. What's going on here? Someone's trying to get a judgment against me. So let's talk real quick about the process here. If you've watched our other videos, this is going to repeat a few things. If you haven't seen our videos before, we thank you for joining us and watching. But basically, when you're in litigation, you always start with this complaint. That complaint is the thing that triggers what's going on here. So the complaint is filed. These little boxes are my documents here. These are my documents. So you have a complaint that's filed. In federal court, you're going to get 20 days to respond to that complaint. If you don't respond, the other party gets to come in and file for a default, to take your default, okay? So the complaint is filed, the papers must then be served on you. Federal courts have a little more liberal standard than the state courts do, but you have to give notice of the summons and complaint reasonably calculated to provide actual notice of the lawsuit. So these service issues sometimes can become a big issue where somebody's being served at the wrong place, or they're not being served at all, what we call sewer service, where you just throw it in the sewer and go, yeah, proof of service, we served them. Cheating, lying, sewer service. So what happens is you've got this 20 days, the complaint's filed, you have 20 days to respond. Your response options in federal court are basic. You can file your answer, which basically says, I deny this, I admit that, I deny that. So you can file an answer, or another popular favorite is a motion to dismiss. For example, you say that there's a lack of personal jurisdiction or other grounds, what we call the 12B motion. So if you want to look that up, we should do another separate video on 12B motions, the grounds for filing a 12B motion. But like personal jurisdiction is a big one. If you're an out of jurisdiction, you're out a company that's out in Europe or Australia or something, you're being sued here, you may say, well, there's no minimum contacts. Why am I being served here? Motion to dismiss. So what happens is within this 20 days, if you fail to plead or otherwise defend, there's your magic keywords, and that's why we're circling it. If you fail to plead or otherwise defend, in other words, if you don't come in and do something in the federal court, that's when the other party may move to take your default. Now the default, this comes under Rule 55. It's basically a two-part process, okay? So the plaintiff in these cases has to be considering and thinking about two separate things, okay? One is filing the default. They haven't filed within 20 days. You file a document with the court saying, please enter the default. Please enter the default. So the default, once it's entered, the clerk will look it up and say, yeah, it's been 20 days, valid proof of service of the document, so yeah, default. Now the default doesn't end the case, it doesn't end there. The default, what it does is it sort of seals you off. It seals off the defendant from coming in and pleading or otherwise defending. It cuts you off. So at that point, and what it does, it admits, essentially, it's deemed as an admission as to the liability portion of the case, but it is not an admission to the damages portion of the case. So that's something that's left to be determined. But so you have the default, admits the liability, not the damages, and that's because, again, you failed to come in and provide some sort of response. Now, this is sometimes where clients will call us saying, help me. They've got a default, I was never served, I just got served, that they're going to file the second part, which is the application for the default judgment. And as I put here, service of process, this also has to be served on you. This is the second part of the two-part test. So people will call here and they say, I just got served their application for the default judgment, and that was served on me. So people will call us often during this period here. Now they're being validly served for some reason. You're like, wow, now they actually served you. Okay, so that gives us a chance to come back in and look at what we call trying to set aside the default. Set aside the default. Okay, so the two-part step is what? One, filing for the default, and then the plaintiff does step two, which is file for the default judgment. That's the judgment that they're going to wave around and try to enforce. If it's in another jurisdiction, they're going to domesticate the judgment in the other jurisdiction and then go try to enforce in that jurisdiction. That's a whole nother ball of wax. But where we may come in is to set aside the default. Here's what the courts look at. It's discretionary. The courts have wide latitude. And what they're looking for is good cause. Good cause. In other words, a good reason. Why didn't you answer? Why didn't you plead? Why didn't you file a motion to dismiss? So the court's looking for a good reason that you didn't do that. If you have that, the court may just go, okay, set it aside, get back in here and go file something, do something, okay? You're in court, file something, do something. So the default, that's where we come in. Again, it's a good cause standard. Courts have broad discretion. The courts favor a final decision on the merits of the case. This can't be overemphasized. The courts want you to have your day in court. So these defaults are actually disfavored, and a hearing or trial on the merits is favored. So it's very important to make that case to the judge when you're coming in with these default set-aside motions under Rule 55 of the Federal Rules of Civil Procedure, FRCP, Federal Rules of Civil Procedure. That's what governs in the federal courts across the country. And the courts are going to look at these factors. Now I'm going to give you three quick factors. If you're filing this motion or contemplating file this motion, they're going to look at the defendant's culpable conduct, the defendant's conduct. Why didn't you file something? Why didn't you do something? Why? Was it a result of failure to be served? That's a good reason. Was it a mistake, excusable neglect, some sort of surprise as we call it? Was there fraud somewhere in the process? They're going to look at these things. Now, some common things that may not work, they may, but may not, probably not. Oh, I was just so busy. I was so swamped at work. I just couldn't find the time. Oh my gosh, it slipped my mind. You have to be careful with those kinds of defenses. Also, I didn't have money for an attorney. I was calling my friends trying to rustle up the money. You can try these things. I'm not saying they're losers, but you want to have these good bona fide reasons, okay? The courts will also look at, this is very important, whether you have a meritorious defense, okay? So you could be, for example, well, it doesn't matter. You could be involved in a copyright lawsuit and they're alleging that you're infringing the copyrights, and you say, well, I have 5 licenses right here. You're saying I'm 5 short. I have 5 licenses right here. Let's just say Microsoft or Autodesk, IBM, Oracle, whatever. And you say, I have my licenses right here. So that's a meritorious defense. The courts want to know, if I'm going to reopen up this process, if we're going to reopen this process up and let you come back in and plead, file an answer or a motion to dismiss or do something, that you have something meritorious, okay? So that's a big part of it. Bear that in mind. And the courts may look at the prejudice to the plaintiff. Again, that's a small factor. The courts prefer the trial on the merits. But if there's something significant there, the judge could hang their hat on that. So, okay, so you have to be aware these are the factors to set aside. If you fail to do that and you never get to that step and they get to the default judgment application, this is where the plaintiff is going for the jugular. They're going for the damages. They're going for that piece of paper that gets them the judgment. So this is where the game's going to really be ratcheted up. You're going to see the default judgment application. You're going to see proposed findings of fact and conclusions of law, really trying to sell that judge on the case. Remember, in cases, the plaintiffs almost always, I should say, there are circumstances where the burden shifts, but the plaintiff is normally going to bear the burden of proof. The burden of proof. Okay, if you don't know what that is, Google Vondren, burden of proof. We have a video on that, explains it in 2 minutes for you, okay? But the default judgment application that may have evidence attached, they may have affidavits attesting to the service of process that we validly served, and so there could be lots of different types of evidence, but the plaintiff is going to meet that burden of proof, and the court can either enter the judgment as requested, or the judge at their discretion, his or her discretion, can set what we call a prove-up hearing. A prove-up, that's where the plaintiff has to show up in court get dressed up, have the big briefcase and exhibits and everything, show up and prove the case. The nice thing about that is these are the nicest hearings that you'll ever be in as an attorney, because you won't have somebody objecting, opposing, contradicting, rebutting. You won't have somebody doing all that. You're on your own, but you have to sort of meet the burden threshold so that the judge will say, okay, we'll give you that judgment. Okay, $500,000 copyright infringement, $500,000. You got it. So that's the prove-up hearing. Now, the 4 things at the prove-up hearing that may go on, and this is per the code here, is the court may conduct an accounting. They may account and see what's going on, put things together. They may establish or rebut truth of your allegations. So again, you do have to come in and be able to show what you're saying is truthful. And determine damages. That's the big one, determine damages, because that's really what you're there for, is to come out of there and go, you know, we got this damage award, we got it. And to have something that you can then go and try to enforce. You know, the old saying, sometimes a judgment is only as good as the paper it's written on. You still have to be able to go out and enforce that, and hopefully your defendant or defendants have assets to go after, okay? And the court may investigate other matters. That could be, you know, from here to there. It could be lots of different things. But this is what could go on in a prove-up hearing, okay? When the hearing's done, you have your final judgment stamped, approved. There it is, certified by the court. You've got your judgment. Hooray, that's what you're looking for. And then finally, where also we end up, sometimes people coming to us with cases, is I want a motion to set aside the default judgment, this judgment right here, okay? So they may be saying, they come to me and they say, this whole process happened, I had no idea, I wasn't served, or this or that, or I was ill in the hospital, and now there's a $500,000 judgment against me for willful copyright infringement. I want to fight that. I want to open that back up, and I want to come in and fight this case on the merits. Get back here and file my motion to dismiss, or file my answer, and I want to defend this case, or I want to file a countersuit. I want to come back and sue them because they actually owe me. So there's lots of different things that can go on. Motion to set aside. What are the grounds the court's going to look at? This is under Rule 60B. So you have the 2-part process here under Rule 55. Now we move over to Rule 60B of the Federal Rules of Civil Procedure, FRCP, right? So you're getting good at this. So FRCP, now it's the same things. The court are going to look at the same factors that we had here to set aside. Is there good cause, mistake, inadvertence, surprise, excusable neglect, those kinds of things? Is there a meritorious defense? Remember, we talked about this. You have to have a real defensible position, something where you say, I did not do that. Was it willful and bad faith? Was there newly discovered evidence? Was there fraud? Is it a void judgment? Is this something where the plaintiff is coming and trying to get a judgment on something that's already been paid or satisfied? Where you say the judgment's void, it's paid, satisfied, released. What's going on here? So that's another grounds, or other valid reasons. Now, for these ones that I have checked in green, if you can see that, mistake, excusable neglect, inadvertence, newly discovered evidence, and fraud, misrepresentation, those are three different grounds. Those motions should be brought within 1 year. There may be some exceptions for equitable tolling, which we've talked about in other videos, or if it's any of these others, bring it within a reasonable time. Reasonable time, what's that mean? Whatever you can make it mean as a good advocate, okay? So that's the basic difference between a default, which is step 1, stamping the default, and the default judgment, which is actually having that piece of paper that you can wiggle around, and your 2 different mechanisms for trying to set these aside and get your trial on the merits, okay? So this is Attorney Steve Vonner, and I hope this has been helpful for you. We handle business, real estate, and intellectual property litigation. If you need an attorney to help fight for you and get you justice, give us a call. We're happy to help you out. You can find out more information on our website at askattorneysteve.com. That's askattorneysteve.com, and make sure you click on that red V box, wherever they put it these days. Could be over here now. Click on that so you get these free legal updates coming to your inbox, okay? As we like to say, be smarter than your friends, okay? Attorney Steve Vondran, thank you for joining us. Feel free to share this video on your social media networks. Have a great day.